ASEAN Convention Against Trafficking in Persons, Especially Women and Children, Episode 1, Preamble and General Provision. Member States of the Association of Southeast Asian Nations, hereinafter referred to as ASEAN, Brunei Darussalam, the Kingdom of Cambodia, the Republic of Indonesia, the Lao People's Democratic Republic, Malaysia, the Republic of the Union of Myanmar, the Republic of the Philippines, the Republic of Singapore, the Kingdom of Thailand, and the Socialist Republic of Vietnam, hereinafter referred to individually as the party and collectively as the parties. Recognizing that trafficking in persons constitutes a violation of human rights and an offense to the dignity of human beings. Recalling the purpose and principles of the Charter of the United Nations, the Universal Declaration on Human Rights, the Charter of the Association of Southeast Asian Nations, ASEAN Charter, the ASEAN Human Rights Declaration, the United Nations Convention Against Transnational Organized Crime, and where applicable, the Protocol to Prevent, Suppress and Punish Trafficking in Persons, especially women and children, and other international agreements and resolutions of the United Nations on the eradication of trafficking in persons, in the promotion and protection of human rights, fundamental freedoms, fair treatment, rule of law and due process. Reaffirming our commitment to the ASEAN Charter with a view to responding effectively, in accordance with the principle of comprehensive security, to all forms of transnational crimes and transboundary challenges. Reaffirming also our commitment to the ASEAN Declaration Against Trafficking in Persons, particularly women and children, adopted in 2004. The criminal justice responses to trafficking in persons, ending impunity for traffickers and securing justice for victims in 2007, ASEAN Practitioner Guidelines, the ASEAN Leaders' Joint Statement in Enhancing Cooperation Against Trafficking in Persons in Southeast Asia in 2011. And ASEAN's efforts in promoting human rights, including the ASEAN Human Rights Declaration adopted in 2012. Reaffirming further our commitment to a stronger and more effective regional and international cooperation against trafficking in persons where the offense is transnational in nature, including but not limited to crimes committed by organized criminal groups. Recognizing that cooperation is imperative to the successful investigation, prosecution and elimination of safe havens for the perpetrators and accomplices of trafficking in persons and for the effective protection of, and assistance to, victims of trafficking. Recognizing that trafficking in persons is caused by a combination of factors, including government corruption, poverty, economic instability, inefficient legal systems, organized crimes, and the demand that fosters all forms of exploitation of persons, especially women and children. That leads to trafficking, which must be effectively addressed. Realizing that all ASEAN member states, regardless of whether they are countries of origin, transit or destination, have a shared responsibility and a common goal to prevent trafficking in persons, prosecute and punish offenders of trafficking in persons, and to protect and assist victims of trafficking in persons. Taking into consideration the proximity and connecting borders of ASEAN member states and in the spirit of regionalism. Realizing the need to establish a regional instrument that deals especially with trafficking in persons as a legal framework for regional action in preventing and combating trafficking in persons, including the protection of, and assistance to, victims of trafficking in persons. Recognizing the importance of having in place a regional instrument against trafficking in persons that is legally binding and that would assist ASEAN member states, as countries of origin, transit or destination, to deal with their diverse national challenges. Priorities and strategies in the fight against trafficking in persons. Have agreed as follows. Chapter 1, General Provisions. Article 1, Objectives. 1. The objectives of this regional legal instrument are to effectively A. Prevent and combat trafficking in persons, especially against women and children, and to ensure just and effective punishment of traffickers. B. Protect and assist victims of trafficking in persons, with full respect for their human rights, and C. Promote cooperation among the parties in order to meet these objectives. 2. The parties agree that the measures set forth in this convention must be construed and applied in a manner that is consistent with internationally and regionally recognized principle of non-discrimination, especially to those persons on the ground that they are victims of trafficking in persons. Article 2, Use of terms. For the purposes of this convention, A. Trafficking in person shall mean the recruitment, transportation, transfer, harboring or receipt of persons, by means of the threat or use of force or other forms of coercion, of abduction, of fraud, of deception, of the abuse of power or of a position of vulnerability or of the giving or receiving of payments or benefits to achieve the consent of a person having control over another person, for the purpose of exploitation. Exploitation shall include, at a minimum, the exploitation of the prostitution of others or other forms of sexual exploitation, forced labor or services, slavery or practices similar to slavery, servitude or the removal of organs. B. The consent of a victim of trafficking in persons to the intended exploitation set forth in paragraph A of this article shall be irrelevant where any of the means set forth in paragraph A have been used. C. The recruitment, transportation, transfer, harboring or receipt of a child for the purpose of exploitation shall be considered trafficking in persons even if this does not involve any of the means set forth in paragraph A of this article. D. Child shall mean any person under 18 years of age. E. Victim shall mean any natural person who is subject to an act of trafficking in persons as defined in this convention. F. Organized criminal group shall mean a structured group of 3 or more persons existing for a period of time and acting in concert with the aim of committing one or more serious crimes or offenses established in accordance with this convention, in order to obtain, directly or indirectly, a financial or other material benefit. G. Serious crime, as stated in paragraph F of this article, shall mean conduct constituting an offense punishable by a maximum deprivation of liberty of at least 4 years or a more serious penalty. H. Transnational crime shall mean an offense that is transnational in nature. An offense is transnational in nature if I. It is committed in more than one state. 2. It is committed in one state but a substantial part of its preparation, planning, direction or control takes place in another state. 3. It is committed in one state but involves an organized criminal group that engages in criminal activities in more than one state, or 4. It is committed in one state but has substantial effects in another state. I. Public official shall mean I. Any person holding a legislative, executive, administrative or judicial office of a party, whether appointed or elected, whether permanent or temporary, whether paid or unpaid, irrespective of that person's seniority. 2. Any other person who performs a public function, including for a public agency or public enterprise, or provides a public service, as defined in the domestic laws of the party and as applied in the pertinent area of law of that party. 3. Any other person defined as a public official in the domestic laws of that party. J. Property shall mean assets of every kind, whether corporeal or incorporeal, movable or immovable, tangible or intangible, and legal documents or instruments evidencing title to, or interest in, such assets. K. Proceeds of crime shall mean any property derived from or obtained, directly or indirectly, through the commission of an offense. Freezing or seizure shall mean temporarily prohibiting the transfer, conversion, disposition or movement of property or temporarily assuming custody or control of property on the basis of an order issued by a court or other competent authority. Confiscation, which includes forfeiture where applicable, shall mean the permanent deprivation of property by order of a court or other competent authority. Predicate offense shall mean any offense as a result of which proceeds have been generated that may become the subject of an offense as defined in Article 7 of this Convention. Article 3, Scope of Application. This Convention shall apply to the prevention, investigation and prosecution of the offenses established in accordance with Article 5 of this Convention, where the offenses are transnational in nature, including those committed by organized criminal groups, as well as to the protection of and assistance to victims of trafficking in persons. Article 4, Protection of Sovereignty. 1. The parties shall carry out their obligations under this convention in a manner consistent with the principles of sovereign equality and territorial integrity of states and that of non-intervention in the domestic affairs of other states. 2. Nothing in this convention entitles a party to undertake in the territory of another party the exercise of jurisdiction and performance of functions that are reserved exclusively for the authorities of that other party by its domestic laws.